Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we're back in Murray, Kentucky, down here in Callaway County with attorney Jeff Roberts. And today we're going to talk about some of the frequently asked questions, some of those initial questions that he receives from clients when they come in to talk about their car wreck, their motorcycle wreck, their truck collision, their motor vehicle claims. It's a complicated area of law, and luckily for us, Jeff's been doing it for about 30 years, so he might know a few things. Jeff, welcome back.
Hello, Jim. How are you today?
Well, I'm doing great. I'd love to come down here, love to talk with you about this stuff. You know, car wrecks are complicated in a lot of different ways. There's a lot of moving parts usually that happen, and especially if you've never been in one, you really don't know what to do other than pick up the phone and call an attorney and try to figure out, okay, where do I even begin? And hopefully today you're going to shed some clarity on some of the things that are going to happen and how it all plays out. Yes,
I thought today we would talk about the questions that I'm frequently asked when I initially meet with a client about a motor vehicle collision, whether it's car wreck, truck wreck, semi wreck. You get similar questions, and frankly, if you listen to the last episode where we talked about frequently asked questions in workers' compensation cases, the questions I get frequently in motor vehicle cases is very, very similar to those. The answers are different from that standpoint. That's the reason I thought it would be good to address those in different podcasts, because the answers are different depending on which type of case that you have.
So you've got about 5 or 6 common questions that we're going to go over today. You want to kind of give us an idea of what we're going to talk about?
Exactly. One of the first questions, or the questions that I frequently get asked for motor vehicle cases, is one of the first ones is going to be, who's going to pay my medical bills? How are my medical bills going to be paid? If I'm out of work, who's paying me while I'm out of work, my lost wages? Another is, what's it going to cost me to have you involved in the case? Having an attorney, what's the cost there? What's my case worth? And then how long it's going to take to resolve the claim, and whether they're going to have to go to court. Those are questions that I frequently get asked by a lot of people when they come in to see me on a motor vehicle collision. And it's understandable, because it's the first time they've gone through this process. They don't know those answers, and those are things that weigh heavily on them, or that they need to decide on what they want to do or how they want to proceed. So I understand them being curious about those things.
Well, let's go ahead and jump in, but I know we're talking about, this is Kentucky, and it may be a situation where somebody's been driving from out of state, they come through Kentucky, they're involved in a collision, and they go back home. So again, the laws in their own state may be different. So this is going to be specific to Kentucky motor vehicle accidents.
Correct.
All right.
Yes.
Well, let's go ahead and jump in.
Okay. Well, the first question I'm frequently asked is, who's going to pay my medical bills? And, that is, and it's understandable because, a lot of people don't have the excess income to cover deductibles and copays that they haven't been planning on from that standpoint. So that's a big question they have. And, with a motor vehicle collision, it's very different on how you deal with medical than it is with a workers' compensation claim that we talked about the last episode. In Kentucky, there is, when you're involved in an accident, the vehicle you are in is the one responsible for paying the first $10,000 of medical and or lost wages. That's referred to, we've talked about it before, it's referred to as PIP benefits, personal injury protection benefits. In fact, it goes by multiple different names.
No fault.
No fault coverage, or basic reparations benefits. So it has different names for the exact same coverage. Or exact same thing we're talking about there.
And again, that's regardless of who causes the act, who's at fault. It doesn't matter. That's, again, why we refer to it often as no fault.
Correct.
There's money available based on the car that you're riding in at the time of the collision.
Correct. And so it pays. And the reason that is because oftentimes there is a dispute as to who is at fault in causing the collision. And to avoid people not being able to get medical treatment, Kentucky has the basic reparations PIP, no fault benefits, that pays, and it's easy to figure out which car you were in. They pay the first $10,000 of medical for everybody in that vehicle. It's not $10,000 divided among all four members. Each person in that vehicle has at least $10,000 of coverage for that. And then when you determine who's at fault, the at-fault insurance will reimburse the non-at-fault insurance for what they've had to pay out in those coverages. But the medical treatments, the person's able to get medical treatment.
Now, $10,000 doesn't go as far as it used to, but it sure as heck can get you, to a primary care physician. It can get you to a chiropractor. It can get you to an X-ray if you need one. It can kind of get the ball rolling, so you don't have to wait for quite a bit of time.
True. Now, if you come to see me and retain me, we're going to tell the no-fault carrier, the PIP carrier, to not pay anybody to start with. And there's a reason, and I have clients look at me just like you looked at me when I said that, and that's because they're saying, well, why are we going to do that? And the reason that I do that is because I can stretch that $10,000 to cover more medical if we do that. And here's how. PIP or no-fault coverage is the only coverage that I'm aware of that pays the doctors in the hospital 100% of the billed amount. So if you go to the emergency room and the bill is $7,000, PIP is going to pay them $7,000. If you have health insurance because of your health insurance carrier's contract with the hospital, that $7,000, they have an agreement that those are reduced, and the payment may only be $3,500 for that $7,000 bill. And now you may have copays and deductibles that apply to that, but the hospital is still bound by that contract with the health insurance. So health insurance may only pay $1,000 of that bill, and you be responsible for $2,500 of that bill because you haven't met your deductible yet. But then we can use the PIP to pay that $2,500 deductible, but we've wiped out $7,000 of medical bills with the $2,500 payment to them. Now, health insurance might get reimbursed later on, but that's the reason I do that is when we let health insurance take care of the medical bills first and then use the PIP money to reimburse deductibles or to pay deductibles or reimburse the health insurance, we stretch that $10,000 to cover $17,000, $20,000, $21,000 of actual medical treatment in that situation. And so, when we do that, it allows the client, when the claim is resolved, not to have to pay the health insurance back as much money because they're going to get reimbursed eventually at some point in time for whatever health insurance has to pay. If your medical bills are $10,000, or $15,000, we let PIP pay 10, we let health insurance pay the other 5, which they pay with 3. When we resolve the claim, health insurance is getting $3,000 of that final settlement, whereas if we let health insurance pay that $15,000 by paying $9,000, we reimburse health insurance $9,000 from PIP. We still have $1,000 left over of PIP, and you get to keep every bit of the settlement at that point in time. So that it just stretches my clients' money and lets them put more money in their pocket.
I mean, that's a lot of numbers. That's a lot of math. But the fact is, with 30 years of experience, you understand how to do this to maximize the value for your client. And I think that's the bottom line here.
Correct.
Is that, again, having an experienced attorney on your side makes a world of difference. And that's, again, Jeff, you've been doing this. You've got your Murray office. Now you've got a Hopkinsville office as well. And you've been involved in cases all across the state of Kentucky. Correct.
And that come from years of experience. I do have, I've had clients come to me when they've had somebody else before, and that person stopped practicing or something of that nature, and they didn't do that, reserve that PIP money for that, and ultimately what my client put in their pocket because that money had already been used. I didn't have the option to do that. It's a little less than what it would have been otherwise from that. And it comes from experience. When I first started practicing, I'm sure I did not do that. I may have just because I started practicing with another attorney who did personal injury work, and he trained me, so he very well may have been doing it in one that taught me to do that. I can't recall. It's been 30 plus years ago. The next one is lost wages, and it kind of comes back again to the PIP benefits there, because under Kentucky law, that $10,000 is used to pay medical and or lost wages. It can be used for other things, but that's 99% of the time that's what it's used for. And unfortunately, these numbers were set in the statute back in 1977, 1978, when the Motor Vehicle Reparations Act was passed in the legislature, and they haven't adjusted it. And lost wages are capped at $200 under the law. So all we can get you from PIP benefits is $200 a week for lost wages, but that's better than $0 coming in a week. So also another reason to reserve the PIP money or the no-fault money is to use it for lost wages. So if you are out of work, it may only be $200 a week coming in, but let's keep that money to pay you while you're off work, and then we'll deal with medical and health insurance at a later time. But you at least got a little bit of money coming in at that point in time. If you've listened to very many of my podcasts, you will have heard me tell people one of the types of insurance coverage you need to have, in addition to motor vehicle insurance, which is required, is short-term disability benefits. And one of the very reasons for that is when you're injured in a car wreck, unfortunately, $200 is all you're going to get a week until that $10,000 is exhausted. And once that $10,000 pays, if it pays $9,000 to an emergency room bill, then you've only got 5 weeks you're off before that $10,000 of PIP money's used up, and then you don't have any money coming in because that coverage is exhausted, and the at-fault driver's insurance is not going to pay you anything until the case is resolved and they settle everything at one time.
And that's another big difference between a workers' comp claim and a personal injury claim. In a personal injury claim, no money's really dispersed until the end of the situation, right?
Exactly. The PIP money will pay as it's being incurred if you allow it to do so, if you don't reserve it. It'll pay the medical bills, and it'll pay the lost wages as well from that standpoint. But once that's exhausted, there's no other source of paying other than health insurance or other insurance you may have until the case is resolved. And then that's when the at-fault party's insurance would kick in and pay to reimburse those things from that standpoint. But if you have the short-term disability, which I strongly encourage people to have, then that's going to kick in and pay while you're off work as well, and will pay much greater than the $200 a week at that point in time. And so I've had clients that have been off work for a long period of time, and luckily they've had friends and family that have helped them out in that situation, but some have been very close to losing cars and homes because of how long they were out of work because of the motor vehicle collision and the money. And the way the law is in Kentucky, unfortunately, the PIP law has not been changed in, I guess, close to 50 years now. And $200 back in 77 went a long way. $200 in 2023 does not go very far at all.
Absolutely. So, Jeff, I mean, this is, again, it's complicated stuff, and that's why I always advocate for someone that's been in an accident. You need to talk to an attorney. Yes, you could do it on your own, but there's a lot of moving parts and a lot of places where you might slip up and just not realize what actually is going on. And that's why it's really great to have somebody right beside you who actually knows this area of law very well.
Exactly. And at least you go talk to an attorney. You come in to see me about your motor vehicle collision. The initial appointment's free. There's no cost to the initial appointment. You get the information that's specific to your situation at that point in time. And then you can make the decision on whether you want to hire me or don't want to hire me at that point. And if you hire me, great. If you don't hire me, at least you have some information now that help you in navigating it on your own you're most likely not going to do as well on your own as if you had an attorney, but at least you have a little bit better information. The insurance company and the insurance adjuster has, they've been trained. They know what the law is. They got attorneys advising them. It's only good to have an attorney that's looking out for your interest as well. The next question that I frequently get at these is, what's it going to cost me to hire you? And a lot of times they think, okay, I don't have money to pay you to retain you to represent me in this case. How much am I going to have to write you today for you to get involved in this case? And a lot of people are surprised to hear that I don't get paid until the end of the case. The way I work on these cases is on a contingency fee basis. That means that I'm paid at the end of the case, and my fee is contingent upon the recovery. The better I do for you, the better I do for myself. In a car wreck case, motor vehicle, truck accident case, the fee is going to be 1/3 of the recovery. That's what the standard fee is for me. Some have gone up. I've been 1/3 of the recovery is what I've been charging for 30 years now. Some attorneys have gone up on what they charge. I'm staying at 1/3 right now, and so the more I recover for you, the more I recover for myself from an attorney fee standpoint.
Well, and I've seen some agreements from other law firms that say, well, it's a 33%, it's 1/3 up front here, but if we go to trial, then it increases even more. How does your firm handle that?
In my case, my attorney fee is 1/3, whether we go to trial or it settles pre-suit. From that standpoint, if going to trial is what my client needs to do to get full value for their case, then that's what they need to do to get full value. And I don't want it to be
punitive.
I don't want my attorney fee to be the decision for them to take less than full value for their case, because the attorney fee is going to go up by 7% or nearly 7% if they go to trial on the case or if we file suit on the case from that standpoint. So I don't do that from that perspective. It just, to me, the decision on whether to settle a case should be based on whether the settlement's a fair value for the case, not is it going to cost me more to go to trial than that. Now, expenses, because also my expenses are contingent upon recovery. And what that basically means is, when I'm handling a car wreck case, there are various costs associated with it. Accident reconstructionists charged to do their work, and we may have to have them involved. Very well may be that I want to have a medical expert that's willing to come to trial and testify in front of a jury, and that evaluation and that testimony is going to cost money, and I advance that cost. If we do file suit, there's a filing fee when you file suit in circuit court, then deposition costs, and you got court reporter fees and things of that nature. All of that's advanced by me and is contingent upon recovery as well. So if we are successful in the case, I get paid my attorney fee and reimburse my expenses. If we are not successful, then you don't owe me attorney fee. You don't owe me reimbursement of my expenses. You're not out a penny if we're not successful in the case. But then one thing when we're talking about some attorneys increase the attorney fee if they file suit or if they go to trial. And when you go to trial, the expenses go up drastically at trial because experts coming in, the accident reconstructionist may not be from around here, and then we have to pay for their hotel room and for a full day of trial testimony and their travel, and the same with a medical expert. So those costs, the cost of a trial, the costs go up drastically, and it's only fair that the client know that ahead of time. If it's going to cost $15,000 more in cost to try the case, and the offer is $15,000 less than what I think the case is worth, they may want to say, yeah, let's go ahead and do that because it's going to be what I net if we try the case.
Well, you don't have the risk of a jury or a judge saying,
exactly.
hey, we're going to go the other way on this.
So there are, that's something that the client's got to take into account, needs to be advised on and take into account from that perspective. But they should not be saying, I don't want to go to trial because my attorney fees going to get goes up from
Yeah.
that standpoint.
Yeah, they shouldn't have
At
to
least
worry
from
about
my standpoint, they shouldn't have to do
I
that.
agree completely. And it's, obviously the expenses go up, but you know what? Fair value is fair value. And if that's what it takes, that's what it takes. I love the fact that you stand behind that.
Right.
Jeff, there's a lot that goes into these cases. And again, because of this, if you have a serious injury from an accident, be that a motorcycle wreck, a truck wreck, or a car wreck, whatever it is, you don't know these experts. You don't know how to get a constructionist. I mean, that's the value that an experienced attorney actually brings. And again, people are always worried about attorney's fees, but in reality, there's a lot that they get for that. It's not just the attorney fee, it's the knowledge of how to really put the case together so that you ultimately have a better chance of winning.
True. And, the insurance company knows the case, but they also know if someone does not have an attorney, they know they don't know how to file the claim and get it in circuit court. They don't know how to draft a complaint and file it to get the case in circuit court. And they also know that there's a statute of limitations on these cases, and most clients that I talk to have no idea what a statute of limitations is.
Luckily for them, you have a podcast episode on the statute of limitations. So, friends, I will link to that in the show notes.
I do have a podcast on the statute of limitations. And so the insurance company knows that if they drag you out long enough by promising, okay, we're looking at it, we're going to get you an offer out, and they drag it out long enough, that statute of limitations expires. Now you're not going to be able to pursue that claim. And so every personal injury case in Kentucky has a statute of limitations. It varies depending on the type of case. Workers' comp has one statute of limitations. Motor vehicle accident has another statute of limitations. Medical negligence, premises liability, all of them have statute of limitations, and they vary depending on type of case. So speaking to an attorney about your case, at the very least, to learn what your statute of limitations is a very good thing from that perspective. And so you can make sure you don't let that expire, because if you let that expire, you very likely are not going to be able to pursue that claim any further.
Well, I would think during the negotiations, during the pretrial workup, and then actually when the litigation is ongoing, there are also timers on you have to respond in X number of days, or you have to respond in X number of some kind of time frame. And if you miss that again, that could also damage your case and your ability to prevail.
Yes. Now, those kick in after the, as far as discovery deadlines and all, those kick in after you filed the complaint. If you file the complaint pro se, which means without an attorney, then you're going to be held to the same standards as an attorney. And there are certain things that the insurance can do, or the defense attorney can do, that can take advantage of the fact that you don't know the rules.
And it happens every day.
Yes, it does. And that can come back to have devastating consequences on your case if you don't timely respond to certain things. And so, as far as filing the complaint, I don't recommend anybody file the complaint without an attorney, because you're held to the standards of an attorney, but you don't know the rules like an attorney knows the rules, and you're going to have a much worse outcome than you would if you had an attorney involved in your case.
That makes a lot of sense. Jeff, what's the next kind of common question you get from people?
The next question is, how long is it going to take to get the case resolved? And, that varies from case to case. One of the big questions is how long it takes you to recover from your injuries. In any type of personal injury case, one of the factors that is an important date is when you reach maximum medical improvement. Maximum medical improvement means the date that you're not likely to have any significant improvement in the future. You may still be getting treatment to keep you from having setbacks or to maintain where you're at. A lot of times people reach maximum medical improvement and they're still on medication. May have yearly follow-up visits with the doctor or every 6 months follow-up visits with a specialist to make sure things are staying where they need to stay at and not going backwards. But you're not expected to make any significant improvement after that date. And you don't really want to try to resolve your claim until maximum medical improvement occurs, because we don't know what your permanent problems are going to be until then. We don't know if you're going to have permanent restrictions. We don't know if you're going to have more surgery or not. So there's a variety of things that we just don't know until that occurs, and then we can get that information from the doctors when that occurs, your increased likelihood of future medical treatment and things of that nature. Now, in a motor vehicle collision case, there are times that it's rare, but there are times that I will settle a client's liability case, and even sometimes the underinsured case before maximum medical improvement. I don't like to do that, but there's times where my client's injuries well exceed the liability limits, and it's in my client's best interest to go ahead and settle for liability limits before maximum medical improvement, because, as we said earlier, health insurance is going to get reimbursed. Well, the longer we wait, the more health insurance is paid, the quicker we can get that case settled, get health insurance reimbursed. They still have to pay for future medical treatment. So we can kind of, if we've got low limits, I know there's low limits, we can get the case settled and ultimately the client keep more money in their pocket. But only the only time I ever settle a case before maximum medical improvement is when I'm settling for the policy limits, the most that my client can get from that person.
And that's what I was going to come back to. When you're saying liability limits, you're talking about the amount of insurance the at-fault driver is actually carrying at the time.
Correct. Yes. When you purchase insurance for your motor vehicle, you purchase coverage up to a certain amount. The least amount you can purchase for PIP is $10,000. You can purchase added reparations benefits that will pay up above that. For liability, bodily injury liability covers, the least amount in Kentucky is $25,000. You can purchase 50, you can purchase 100, you can purchase 250, 300, whatever you want to purchase from that standpoint. So you can have higher liability limits. But whatever those limits are, that's the most your insurance is going to pay. Now, if the damages are in excess of that, you're at fault. The damages are in excess, you're subject to being personally liable for that. So, a lot of times people aren't, frankly, a lot of people are what's referred to in the industry as judgment proof, which means they really don't have much in that way of assets to go after. From that standpoint, and even if they do, they have more debt than what they have assets. So if you file suit against them over and above the insurance, they can bankrupt it. You're not really going to collect. And most people have underinsured motorist coverage. Underinsured motorist coverage, as we've talked about before, is your own personal insurance will cover damages above what the liability limits are if your damages exceed the liability limits. And when you access that coverage, then you're getting above the liability limits. Your insurance company is the one paying it, and then they can look back at the at-fault driver if they think he's got assets that they can go back after. Most time they don't ever do that either, because there's nothing there for them to recover, and they realize that.
But at least you have the option of kind of getting made whole or as much as possible based on your policy.
Correct.
And then move on and let the insurance companies deal between themselves or whatever. At least you're out of it at that point.
And another question that comes into play that I didn't ask or didn't mention earlier because it didn't pop in my head, but now that we've mentioned underinsured, another question I'm frequently asked by people on accessing the no-fault coverage, the PIP coverage, and underinsured motorist coverage is this going to make my insurance premiums go up? And the answer to that's no. There's Kentucky administrative regulation directly in point that talks about that they can't raise your premiums for utilizing those types of coverage, because those coverages are being paid out not because you're the at-fault driver in the wreck. Your premium, if you're the one who caused the wreck, either in whole or in part, then yes, that could cause your premiums to go up. But because you've used the no fault coverage, the PIP coverage, or because you've used your underinsured motorist coverage when somebody else is at fault in causing the wreck, that will not make your premiums go up or should not make your premiums go up. And then the final question that I'm asked frequently is, will this case have to go to court? And that's a question I just can't answer. Statistically speaking, no, the case is not going to have to go to court. Most cases settle before a jury trial. Now, a lot of cases, unlike workers' comp, when we talked about that the last episode, I mentioned that a lot of workers' comp carriers don't even try to settle a case before you get it in court or file the claim forms to get it in front of a judge. Now, a lot of times in car accident cases, I'm actually able to settle with the at-fault driver's insurance and even with the underinsured motorist insurance without ever having to file the complaint and get the case in circuit court. But sometimes you have to file a complaint and get it in circuit court and engage in some litigation, get a defense attorney involved. And even then, most of the time, the case is going to settle before it goes to jury trial. But the same holds true as what I said in the last episode. The best way to settle the case for fair value is to prepare the case to be tried by a jury. Because if you prepare the case to be tried by the jury, the insurance company is going to know you're willing and ready to try that case, and you've got it prepared to try. The defense attorney is going to know that you're willing and ready to try that case and are prepared to try the case, and they're going to pay fair value in that situation, most likely. Now, sometimes their value and my value on what the case is worth differ, and we end up having to try the case, and that's okay. But a lot of cases settle for that for fair value because they know the case, you're willing to try the case, and you've worked it up to try the case. If you're not working the case up to try it, they know that as well, and they're never in my opinion, they're never going to offer the full value on that case because they know that the closer you get to that trial date, you're going to settle it because you don't want to try the case.
That makes sense. And the fact is that they all know, they all have extensive databases, and they know which attorneys are ready to go all the way and which aren't.
Correct.
And you're one of those guys who has a reputation for being able to litigate a case.
Exactly. And, and you can't just look at how many cases somebody tries. You have to look at that to some extent. But, attorneys that they know are willing to try cases get fair value and don't have to try them. Frankly, it's been a few years since I've had to try a case. Part of that was because of COVID, because I was supposed to try a case in the May that COVID hit, and it got continued from that standpoint. And then finally, a mediator ended up convincing the insurance company that my value on the case was correct after that. But, it's been several years or it's been a few years since I've tried a case, but that's because I'm getting fair value or getting policy limits on cases. So
Better to have it and not have to use it than have to use it sometimes. I mean, nothing
exactly.
wrong with that. Nothing wrong with that
Exactly.
at all. Jeff, I mean, again, you've handled injury cases all across the state of Kentucky, all across the Commonwealth here. You've got a great reputation. And friends, if you're listening to this, I'm gonna encourage you to go out and look at Jeff's Google reviews and let his work speak through the words of his client. And there are a lot of Google reviews out there, and most of them have some really, really good things to say about Jeff. Because again, it's the way you handle yourself, it's the way you handle your clients, it's the way you handle the cases, and you're working them up for trial. You take that on from the very first step, but you stand by your word, and I think that comes through in so many of those Google reviews. And I'm just always amazed when I go read them or I get a notification that, hey, there's a new one that's been posted. You do some terrific work, and that's echoed, in the words of your clients there. And quite honestly, those are earned. Those are flat out earned. And I just, I know a lot of attorneys across the state, but not all of them have that kind of review structure. Not all of them have that many reviews, and that's just built on a career of doing things the right way.
Well, I appreciate you saying that, and I'm very proud of the reviews that I have for being a solo practitioner. I think I do have a lot of very, very positive reviews for a one attorney law firm. I'm same number of reviews that some firms that have multiple attorneys have, and so you've got like 5 attorneys, so you got 5 more chances of getting reviews from that standpoint. But frankly, and I'm like to think I'm a big part of the review process, but another aspect of that is I've got very, very good office staff that work with me. I've got 2 paralegals that have been with me a long time, a legal assistant, and they their involvement in cases is invaluable from that standpoint. And when you go through and look at the reviews frequently, they refer to the paralegal that was assigned to their case and how well they were treated by the paralegals as well. And so it's a team effort, not just my effort.
Well, I like how you compared the number of your reviews to some of the other multi attorney law firms and some of the law firms in bigger cities. I mean, you've got a motto here at the Roberts Law Office, which is small town service, big city results, and it's proven every day.
Well, I appreciate that, and we try to do that in every case. Absolutely.
Absolutely. Jeff, it's been a pleasure. Thank you so much for your time. And friends, if you've listened all the way to the end here, I want to thank you for your time as well. And please check out the show notes. There are a number of previous episodes that we mentioned in today's episode, and I'll put a link in there to those previous episodes, make it very easy for you to follow them. But feel free to go out to Spotify or Google Podcast or Apple, anywhere that you would normally listen to a podcast, and go ahead and subscribe. There's some really good information in here, and also information we'd really appreciate it if you might consider sharing it with your friends and family so they can be made aware of it as well. And Jeff, it's been a great time. I appreciate the opportunity to let me come down to your office here in Callaway County, and we'll see you in about 2 weeks.
Thank you, Jim.
Take care, guy. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.